So you can have some response on it. Your Lordship, for purposes of clarity and for purposes of not addressing the gallery anymore, permit me to draw the attention of counsel for the Senate to the notice of motion that was filed in respect to the conservatory orders that were granted. The judge sitting in Kiruga, Your Lordship, was categorical that he granted prayer number C, even as we await senior counsel Paul Mwete to come in the afternoon. The wording of those prayers was so explicit that if my good professor had the opportunity of interacting with the document, which I believe he has not, would have come to the conclusion that the orders were drafted in this manner. That pending the hearing and determination, of this application inter partes, this honorable court be pleased to grant the orders that were granted. That is therefore to mean, Your Lordship, that question that senior counsel was raising has no sitting in the pleadings before you. Number two, Your Lordship, since we are here for mention and in the afternoon we are coming for the application for recusal, and I've had the advocates for the respondents insisting on the urgency to hear the application for setting aside, Your Lordship, it is important for the court to note that that application is not predicated on any response. And therefore, if I were them, I would be seeking guidance on how to file their replies. Your Lordship, I hope you are following. He doesn't seem to be following my suggestions.
Why did you say that? Why did you say that?
But let me leave it at that.
No.
Thank you. The directions,
Yes.
subject to amendments which have come from you, will amend it and then upload it.
Thank you.
Yes, but allowed the time commission, if you may be allowed to address the court. And Lord, we are guided by the directions issued by the court. We, however, have one concern from our side, my lords. My lord, there were interim orders that were issued in Kerugoya, and in our understanding, from our interpretation, once the file was referred to this court, the orders expired today. That's our understanding. And my lord, we are going to seek the court's guidance on the hearing of our application dated 18th October. Of course, we understand it is a recusal application today. But given the fact, my lord, that our interpretation is that those orders would expire on the appointed date, which is today, when the matter was meant to be mentioned, our colleagues' understanding, my lord, is that the application, in the public interest, be prioritized so that we are able to hear the application for setting aside of those orders. In any event, my lord, the orders in question were issued by one judge. The matter has now been referred to a three-judge bench. And their nature is problematic, as mentioned by the court. And we would pray that in terms of aligning the hearing or scheduling the applications to be heard in cohort 2, that if possible, my lords, we do not want to do anything outside the law. We would request, my lord, that we be heard today if it's possible, because the orders expire today. I think Malaya Frederick Gumbo would just want to add something on that.
Briefly, I only want to repeat what my lord, I just wanted to indicate that I would not want to repeat what Senior Counsel Professor Tom Agenda has indicated, but just for completeness of record, there are two applications. There's one by the Honorable Attorney General and one by the National Assembly dated the 18th of October 2024. We are ready to be there for them as soon as directed.
My Lord, with your kind permission, Daniel Manso, appearing for the Law Society of Kenya and also for Wiper Democratic Party who are interested parties. My Lord, if the orders are to expire today, then that will be at midnight. My Lord, the day is not yet over. We have applications in the afternoon. We are also affected by those orders. And my Lord, I suggest, after the applications today, then we can discuss that matter before the court adjourns. I thank you, my Lord.
My Lord, Kibe Mungai, on behalf of the petitioners, there are two issues. You can see the senior, the team leader, Honorable Paul Mwite is not with us, senior counsel. That is the first thing that we will deal with it in the afternoon. And as far as we are concerned, the matter is premature at the hearing and determination of that applications for the simple reason that the issue and an order had already been made that will be first dealt with by the court after its ruling of yesterday was the application for recusal. The other matters that relates to how we shall deal with the petition, and we shall deal with all the applications, including the first application for conservatory orders. Those are matters that, as far as we are concerned, are supposed to be dealt with by the directions. By this bench, if it continues, or by any other bench. And therefore, the issue, my Lord, of a back and forth on what is to be had first, the court has already ruled on that. And I believe we need to stick to that. And I am lamenting that even as we sat here, because we have started a little bit late, there is some work we still needed to do with regard to the applications for the afternoon. So we would like any other businesses that is supposed to be done when, for example, Paul Mwite is here in the afternoon, to be dealt with in the afternoon. But my Lord, on the directions, the actual directions that have been given by the court, there are three things actually that we would like our reactions on behalf of the petitioners. Number one, my Lord, is that in giving these directions, we are understanding that the directions are being made pursuant to the Mutunga rules, the rules of procedure that are applicable. My Lord, under the rules of procedure that are applicable, a lot of the petitions that were filed before last Friday and the ones that were filed even on Friday last week are maturing their last dates for responses. My Lord, as we sit here, we are yet to receive any substantive responses to those petitions in either odds from the respondents. And that will have an impact on how soon we can be able to deal with the substantive matters. So, my Lord, I would be expecting that as a further direction, everybody would be required also to comply with the Mutunga rules to the full. My Lord, the second issue is that in all the petitions, the subject matter was the impeachment proceedings. The impeachment proceedings was culminating with the impeachment that was done last Thursday and the facts as they happened on Friday. A lot of these petitions would require some amendment so that they conform with the last position, so that they are not termed as academic. So that, my Lord, towards that, the petitioners, including in the petitions where I'm participating, we had requested formally that we would want 3 days to ensure that any amendments are carried out. And then the respondents would indicate, they have been saying they can do things within a day or two. They will indicate how much time they need to do the responses. Because, my Lord, that would assist in ensuring that whichever bench is going to hear and determine this matter would be able to give final directions, because as you have said, these are interim directions. And number three, in order to be able to determine issues for determination, and these are issues that we deal with when we are doing pre-trial, issues for determinations that are essential in a matter with so many parties, that would require close of pleadings. And the close of pleadings means that all the responses must be given. So that, my Lord, as far as today is concerned, I urge you respectfully that the first thing that can ensure we are moving forward is to ensure that the responses, in accordance with the Mutunga rules, will complete that journey. My Lord, if that is done, it is my view that we will be able to make some progress. In the meantime, my Lord, unless there is any other matter, because there was no other matter that was to be dealt with except directions, we would be happy to leave this place as soon as possible so that we are ready in the afternoon. We are most obliged.
Just before
I think my...
Thank you. We are no longer accepting any further submissions. I'm saying this, that it is not for court to direct parties when to respond to pleadings. It is not for court to direct parties when to respond to pleadings. But one thing which I can assure you that this bench will not allow anybody to take the process of court in circles. So if you have been served the document, whether a petition or an application, if you don't respond, the court is allowed to infer that you have no response. If a petition has been filed and you have not responded to it, the court will make inference that you have no response to that petition. And by the very nature of these proceedings, we all acknowledge that they are public interest proceedings. No party will be allowed to take the court in circles. So I ask you, respond to the pleadings, file your petitions, respond to them. Don't come and ask for leave in a manner to suggest that you want to take this court in circles. We meet at 2:30.
No, we had responded.
They just want to defeat the proceedings.
The proceedings, yeah.
So it's been quite...
That come back and have you. That's how it
Why you?
No, you know this group no. If the hearing proceeds, they have no chance, huh?
No chance.